out. Susan, maybe let me call on you to kind of set the stage for this and where it came from.
Sure. I have been following for several weeks now what's been going on around the country with concerns about remote attestation, remote notarization as well, but also remote attestation. And because we were working in Oregon on the bill for remote notarization, and then we were also going to look at electronic wills legislation, it seemed maybe best just to hold off on thinking about that here in Oregon. The problem is, even if if the legislature adopts the remote notarization for Oregon, it's a process that requires that the notaries be authorized to do that. It's not automatic, and that will take a little while, which means that anybody making the using the remote online notarization in Oregon would be using probably a company that already has notaries licensed to do that in another state, or not licensed, but certified, or whatever it is that they do, whatever it is that notaries do. So, so that was all going on. And at the same time on our estate planning listserv, there was continuing concern about why can't we just change the presence requirement to allow for some kind of presence other than physical presence. For, you know, if we can see each other, we can hear each other, we can see the documents, why can't that work? And that is in fact what other states have been doing. So quite a few other states have, either by legislative action or executive order, have adopted something, either permitting either remote notarization or remote attestation. And I had been kind of tracking that, but more recently had been in contact with a uniform law commissioner from Kentucky. And I was in touch with him about electronic wills, and he said, well, Kentucky just adopted something. And it turned out that he had drafted it, he sent it to me, and I really liked it because it's short, it does the job, and it doesn't kind of get us too bogged down in a lot more than we need. And so I suggested to Lane that we look at that as a starting point. There are lots of other versions around the country, but I like what Kentucky has done. So this comes from Kentucky. Again, it's been restyled for Oregon purposes, but it's pretty straightforward in allowing, I think, what we need in order to allow people to execute documents just during the period when people can't be physically present with each other.
Okay.
Thanks, Lane.
So this obviously is drafted for application during the emergency only. It is not intended to replace the remote notarization bill, which will be a permanent enactment and have its own processes and procedures applicable to remote notarization. Correct?
Yes, correct, Lane. And if I can add in connection with that, I don't think this is the sort of thing that we would want to be permanent. The remote online notarization bill has a lot of protections built in that are very important. And I think in the long term, that's what we want. We want the protections of the remote online notarization bill, the protections of the electronic wills bill. I think both of those would be good additions to the Oregon statutes. What this does is just apply during this period. It's got a sunset. It's just to get us through this particular period when we don't have time to get everything else up to speed. If we get hit with another pandemic, by then we'll have remote online notarization. We'll have notaries who can do that. We may be in better shape, but we're not there yet.
Okay. And just for the information for the group, the attorney who drafted this in Kentucky is Turney Berry. Some of you may know Turney. He's a national speaker on estate planning and a good guy. And so this is his work that sort of identifies where the genesis of this is coming from. First, before we get into the language of it, and I want to welcome everybody here. We got a big group, but it's good to see you all here. Sandy, just as a reminder to those who might have come late, you have muted everybody, but everybody has the ability to unmute themselves. Is that right?
So, Yeah, based off everyone so far, I actually haven't unmuted everyone, but I may if I have, just because it's going well. But if I do sense background noise, I might mute you. If you're on the phone, this is good. And you're on the phone, you can either use your phone mute button or you can use the *6 to mute and unmute yourself on any phone in this system. So if I do mute you, that's how you would unmute yourself. But otherwise, I think we're doing well so far.
Okay, good. So as long as you're all on good behavior, we'll let you operate your own mute and unmute switch. Okay, so let's, Lori Ann, do you want to comment on this kind of globally first, and then I'll open it up to comments globally before we go to the language.
Sure. So this is Lori Ann Sills, and basically the language in the draft very closely mirrors the language from the Kentucky version that Susan sent over. And the main difference between the two is that we have removed the reference to testimony because of a concern that could
Lori, you just dropped off. There was concern what?
Sorry, I somehow got muted. So there was concern that it could apply to witness testimony in court proceedings, and that is already covered by a different statute. So we took that out. There is a small typo in there that I now see. Sorry about that. One concern that I do have about this is the inclusion of notarization, and it's because there are so many other issues involved with notarization that including it in here could be problematic, and that's something that Marisa James could speak more to. She's been the one that's working in the notarization group at the moment, but for the most part, this would just affect the remote witnessing of documents so that a witness doesn't necessarily have to be in the same room as long as they are able to see the person, so on video, so like a video conference, see the person actually doing what it is that they are witnessing them doing.
Okay. On the issue of remote notarization, Marisa, do you want to weigh in? And then Mark Comstock, you might want to have some, let me ask you to weigh in on that too.
Yeah, Mark could go first since he probably knows more about it than even I do. But it seems like if you're going to have the other remote, the RELONA, the remote notarization piece, you wouldn't want to interfere with that. Like that has a lot more heft to it in terms of what needs to happen for notarization to be legitimate. So to me, I would go with that. But okay. Mark.
Okay, I think I've unmuted myself. Marisa has kind of hit the nail on the head here. I think that including the or notarization provision in this, that creates a significant lack of clarity that we don't want to have, because we're already teed up with a version of the remote notarization in the draft omnibus bill that I think is kind of sitting there waiting to hit the legislature. So I think that we'd want to keep that provision separate and not muddy the water, if you will. Okay. I do note that in this draft, it doesn't have a reference to audio in relation to the video, the electronic video communication. I think it's important to have the audio also included, simply because that is one of the safeguards from the notary, the remote notary provision. But I'll listen to everybody's comments.
No, that's good. Thanks. Okay, let me open first just to kind of global comments on the approach of this. We'll get into the language here in a few minutes, but does anybody have anything they want to say generally and globally about the approach of doing this on an emergency basis?
Lane, I want to make sure there's some clarity, just because we did have a meeting with the other group yesterday about potentially seeking a executive action. At this point, we are seeking legislative action hopefully to have this, if we all agree on language, to have this a part of the potential special session. I just want to clarify.
Okay. All right.
So this is Judge Cobb, and my question is, this is in front of the probate modernization group. So is this to address wills and the execution under Chapter 112?
I think it's broader than that. Sandy or PK, maybe if you could respond on behalf of the commission, or Susan, or Mark.
Yeah, I'll take this. Yes, Judge Cobb, this would cover wills, but it's not limited to wills.
Right.
So it would, if we take the by notarization out, it would mean that a will could be attested, signed, witnessed, as long as, and I like the idea of adding the audio. It's kind of odd that it's not there, but that's Kentucky. But the audio visual, so if everybody sees each other and hears each other, the will could be valid. If we take or notarization out, it would mean that the will would not be self-proving until we have that legislative action, which is going to be, it sounds like, another month and a half.
So this broad language that any law, rule, order, so this is to include deeds and powers of attorney and any document whatsoever, it appears.
Right.
Is that correct?
Right.
So
Let me ask about deeds. Then we're getting into the language. If we take out notarization, does that remove deeds from this? Because deeds, at least in order to be recorded, have to be notarized, right?
That's right.
So yeah, so I think if we take out notarization, it would remove deeds from the scope of this, which may be a good thing. I don't know, but that would be one consequence of removing acknowledgement or notarization from this, is that anything that has to be notarized in order to be recorded then would be excluded from the effect of this.
And this is Mark Comstock. I think that we definitely want to keep our title lawyer friends, shall we say, at least satisfied. And if we take out notarization, then we're relying on the remote notarization potential. Right. And the title lawyers that have weighed in on this are comfortable with the remote notarization of deeds, as are county clerks, at least from a representative standpoint. So I think that we definitely wanted to make sure that we don't have any deeds that don't have some kind of notarization submitted for transactions. So I think that at least my position is we want to keep the notarization out, so there's not an argument that this can apply to deeds.
Okay.
Thanks.
well, and that's the basis of this is Judge Cobb again. My question is not getting into the specific language, but the breadth of this legislation. If it's in front of probate, I know probate, but there's a lot of other things this could affect that I have no idea. So do we have everyone who should be weighing in on this broad sweeping change?
I know we have an expanded group, and whether or not we have everyone, I'm going to say the answer to that factually is probably no. But I think we do have a broadly representative group of individuals here. My sense would be to work through this today based on the expertise and the knowledge that we have in the Zoom, and then depending on where we end up, we'll have time certainly for another meeting on this, and expand the group if we need to bring in other areas of interest. Then I think the Law Commission too can do some outreach once we get a feel for what this is beginning to look like, and invite and the bar too, and invite lawyers from other fields to weigh in on this as well. But I think for the purpose of the meeting today, we did expand the group somewhat. But I think the sense of the commission was that this was probably the group to take the first stab at this. And then again, we'll sort of, with an iterative process, see where we end up with this and who else we might want to bring to the table.
And Lane, just as a reminder from the commission perspective, we do have a previously planned meeting for this group next Thursday.
Right.
So we can definitely add anyone who wants to join from a different field, a different area of practice for that meeting will be welcome. We're planning on talking about e-wills there. We can obviously add this to the agenda. And then also, I know we have Amy from the Bar Association, and they've been great partners in getting this information out to various practice listservs as well. So the commission will partner with the bar and make sure that once we have this language that we agree upon, to get that out to as many different practitioners as we can.
Okay, good. So something to be aware of as we work through it. Just how broad are we making it? We've already raised the question of deeds. So let's keep an eye out not only for what's in the language, but what's implied or implicit in the language, and whether we intend the bill to have the reach that it might. Anybody else generally before we dive into the words? And of course, all these issues are live, even as we go through it. So this is not a speak or hold your peace kind of thing. But go ahead. Who's next?
Hey, Lane.
Rick.
Lane, this is Rick.
Yeah.
I guess I'm just a little bit confused mechanically how this process is supposed to work. Yeah, you got a will. So the testator's in one place, the two witnesses are in two other places, they're video communicating. What is each of those individuals signing? I mean, I assume they're all signing separate pieces of paper. How does that all get melded back together, and the adequate documentation to prove that this was done in compliance with this remote process?
Okay, good question.
That's answered in subsection 2 of section 1.
And counterpart.
Can I ask another question?
Yeah, John.
Jane, can I chime in with a question?
Yeah.
If we take notarizations out, which makes sense because we've got a separate bill for that.
Right.
We want this to cover attestations. I'm not sure it does, but
Okay.
other than the testing to a will and notarizing a document, what is it that this is intended to cover?
That's a good question.
I don't know what else we need.
Oh, right.
We put the testimony. We put testimony. in it, which-
Living wills.
Power of attorney?
What's a living
No,
will?
it
Advanced
doesn't-
directives
Power
and mental health directives.
Yeah, advanced directives need to either be, what is it now, witnessed or notarized, isn't that it?
Yes.
Yes.
So let's think about how those would play. Powers of attorney, I don't think the statute requires that they be notarized. I think
No.
anybody who really wants to use one will have it notarized, because a bank won't take it without a notary, and probably neither will the title company. Well, it can't be recorded without a notary. But a power of
Right.
attorney is effective without a notary.
Yeah, and it doesn't need a witness either.
And it doesn't need a witness, that's right. Well, that's a good point. So power of attorney really is an issue aside from this. You don't need a witness to do a power of attorney, but and you technically don't need a notary, but if you want anybody to honor it, you're gonna get one, because it can't be recorded without a notary, and the bank probably wouldn't take it either. So I'm not sure that powers of attorney are necessarily a big issue here, because statutorily they don't require attestation or witnessing. I'm trying to keep an eye on comments as well too, as we got a lot of chat going on. So if those of you if you want to see the chat, click on the button at the bottom of your screen that says participant. Yeah, no, chat, and it'll
Click in chat, yeah.
Chat screen on the right hand side.
And also, if you'd like to, and you're on the computer platform, you can also raise your hand. I see Bonnie has actually raised her hand.
Oh, yeah, that hand raising is always. I don't see that, but go ahead, Bonnie.
Thanks. I didn't want to chime in without
with being trying to not be rude.
Oh,
I
we'll
just
get used to that.
Yeah. So I sent this around to several estate planners just to get their input. I know we have a lot of estate planners here. And the response back that I received was that right now, a lot of estate planners are treating the language in the statute that witnesses have to be present for signing wills, that they can do that over the video. So
Oh,
they
I'm sorry,
just
you
want to
just
be
broke up a
sure
little
that
bit. They
what
can do
they
that
were
over
doing.
what?
They're taking the position that so far during the time of this emergency, that they can have witnesses present by video when they sign the document. So they just didn't want this language to mean that what they have already done is wrong. So that was what they wanted me to say.
Okay. Well, one way to address that would be to make this retroactive to the beginning of the emergency, the declaration. We could do that. That would.
That would be a
Lane?
Who was that?
I think it was
John
Brooks.
Brooks.
That, trial lawyer here, and Dranius is probably going to say the same thing as me. That bothers me a lot because I've already seen all sorts of rather creative pro se stuff out there, and something that blanketly post hoc authorizes or ratifies some of the rather goofy things I've been seeing is just fertile ground for me and my kind to spend a lot of time in court fighting over them, and I'm not sure that helps everybody, although I love it.
Even if what's been done already meets the standards in the statute or in this proposal?
Well, yeah. I mean, as of today, video witnesses and, I watch you sign it, that doesn't work. If you and I are 20 feet apart and I say, Lane, I'm Brooks, I sign my will, and I leave it on the table and I back up and you come sign it, that's fine because we're physically together. There's no rule on how close we have to be. But if you're at home and I'm at home, there's all sorts of opportunities for people to talk about chicanery and forgery and video editing and blah, blah, blah. I'm not sure those thoughts were thought prior to this being enacted. So generally that would worry me.
Okay, what I want to do then is kind of park that issue. Let's get through it and then we can give consideration to whether or how we want it to apply retroactively. I don't want to answer that question yet until we're done with the read through, but I'm going to make a note of that.
Lane, this is Jennifer.
Yeah,
And
Jennifer.
I just wanted to kind of follow up on what Brooks just said. All of those opportunities for chicanery and video editing and all these other bad things, those would exist with this law. And I am preparing to have a client who is in lockdown in a facility in Kaiser on Friday. She is going to sign a will, and I have prepared the attestation and a separate letter that make it clear that that document will comply with the harmless error statute. And I feel like that is a much safer process. It's, I will have had a conversation with that woman right before she signed it. I will have notes regarding that. She will have signed my cover letter saying she understands that this will not have two witnesses, but she intends for it to be her will. The will contains information. And I just feel like that's way more protection than just this kind of Wild West. Yeah, we're on video. You don't know who's standing behind them. You don't know what has been said before the video is turned on. There are just so many possibilities for, the will not being an authentic, intentional act of the testator that I'm very uncomfortable with this.
Okay, so Jennifer, your concern is with the concept as a whole, not specifically the language.
Yes.
Okay, noted.
And this is Judge Cobb. I want to kind of reiterate on behalf of the judiciary, I'm thinking of how I would look at this. I've got pro se people who did this video thing, and what is the standard? What am I supposed to be looking at? What are people be presenting me with? And, yes, I understand that this would have a sunset, but those wills executed at that time could come in, years from now as well.
Right.
And I've got a real concern about how somebody said, how this works is in sub 2. Well, it doesn't really address what Brooks and Jennifer were talking about as far as the possibilities of how do you sign something when you're not there, and how do you know that that was the same thing that you're signing? I've got a lot of concerns about it as far as, if Brooks wants to litigate things, fine, but the courts are going to have to hear it, and there needs to be a lot more safeguards in here for everyone to figure out what's going on, as opposed to having just huge hearings and complete confusion on behalf of the court.
Okay.
And this is Matthew Donahue.
Yeah, go ahead.
Yeah, I've noticed
so let me get Matthew. We haven't heard from Matthew yet. Go ahead.
Hi, this is Matthew Donahue. I'm a judge down in Benton County, and I do handle civil matters, including probate. And I looked at the Kentucky legislation. I guess the question I have, and maybe it springboards what Judge Cobb just talked about. I'm thinking of it from the perspective of a judge. And if I get one of, if we were to get, say, a will several years from now executed during this time, or even something right now that's submitted consistent or in an attempt to comply with these rules, I guess the question is, how am I going to know that? Because it looks like at this point, we're talking about what would satisfy the requirements, which would be you'd have two people not in the same physical location who had audio and video conferencing in real time. All I'm going to get is all the court's going to get under this proposed legislation is that document without any real explanation as to whether it complied with all the necessary requirements to make that document a valid legal document under these emergency rules. So, and I'm just thinking of, and we had a couple people earlier talk about this might be fertile ground for a bunch of litigation. And it would seem to me that we would need something in this that if something's going to be submitted that's attempting to have the remote attestation under this rule, that there's going to need to be something submitted to the court, maybe a declaration or an affidavit by one of the individuals or something like that, indicating that those requirements existed and were complied with, just to prevent, because if something like this does happen and the court gets it, there's going to be a lot of fertile ground for one party who may have some buyer's remorse to attempt to back out of it by saying, well, no, we didn't have audio conferencing, so it doesn't count. Whereas if at least we have one person testifying or submitting something under penalty of perjury that it did occur, that at least would be a starting point for the court to assume that this person who was there was willing to make a declaration that could subject them to perjury, that the circumstances existed to make it legal.
Okay. Good comment. John?
Can I respond to the comments that both judges have made? I've been looking at what other states have done, and the things that I've noticed are three approaches to those issues. One's to require that at least one of the witnesses be a lawyer. Another is to require that the document state that is being executed under the provisions of this emergency procedure. And the third, which I'm not crazy about, but I'll report it because it happens. The third approach is to provide in the emergency order or legislation that the documents have to be re-executed within some period of time after the emergency subsides.
Okay. Very good comments and things that I would like to keep in mind. I do want to try and get through it. And we honestly, this is coming to us as a proposal. I don't think there's any strong sense that this has to be done. I think we want to give it a good shot. We want to make a good effort because it does seem to respond to a need that's out there. But if as a group we get to the end of this after we've worked through it and we think this just, has problems that we can't solve in this short a time, that's where we end. But I would like to give it a good walkthrough and see if we can address some of these issues as we go. And then see what we have at the end. Without any other
Blaine, I think Susan would like to chime in.
Oh, Susan.
Raised my hand. One other thing, and I agree we should go through it, but I was thinking about this as a short term, we get this by in some emergency way. If we are waiting for the legislation at the end of May, that will happen at the same time that we hope to be able to look at the remote notarization and possibly also electronic wills. So that makes it less useful. I was thinking about it more in the interim period, and it makes it less useful to me. The other thing, and I hadn't really focused on this until Jennifer's comments, although I've seen discussion about it on the listserv, is that we in Oregon have harmless error, and a lot of the states that are doing this don't have harmless error. And it does seem to me that we do have that as a backup for the situation where we would, harmless error requires that a judge look at the document, but the document could be executed, if it's being executed, as it sounds like people are already doing, with a different kind of presence. A court could find clear and convincing evidence that the testator intended that document to be the testator's will, use harmless error based on the circumstances of the time, even without, I mean, Jennifer's going the extra step of documenting all of that, even without the documentation in writing, there would likely be testimony and evidence that that's what was going on. It may be that harmless error doesn't solve. The harmless error is enough in the short term, and that we focus more on, if this has to wait for the legislative process anyway, that we focus on the other two bills, which do provide a lot more protection.
Okay. There has been quite a bit of conversation on the listserv about harmless error. And to be honest, I have to say, I know that wasn't popular with a lot of attorneys when we adopted that into the probate code, but it makes me feel good every time I see somebody say they're using it in these circumstances. And I mean, that's a very good comment. Now, there are two possible uses of this language. One would be for a governor's emergency declaration, perhaps, before a special session of the legislature. We don't know how likely that is. And so there's a possibility that this language could come before the remote notarization, but it's also very possible that it would not come before the remote notarization, in which case then go back to your comments, Susan. Once we've got the remote notarization, how much is plus harmless error, how much is this needed?
Lane, this is Sandy. Just to go back, on the topic of a potential emergency action or executive order, if you want, yesterday we discussed this regarding the notarization statute, and that group determined that there was a very clear statutory reason why we couldn't really present that as an executive action. I don't know if we want to have the conversation whether that's even possible with this language. It's really up to the group.
Well, maybe if you could just, Mark, or somebody could just summarize in a few sentences the flavor of that conversation from yesterday.
Lane, this is Mark Comstock, and the remote notarization work group really looked hard at a potential executive order request to the governor. But what we, I think the conclusion was that the provisions of ORS 401.168 were not broad enough to empower the governor to override the specific provisions of a statute. And the notarization work group looked at sub 1 that says During the state of emergency, the governor has complete authority over all executive agencies of state government and the right to exercise within the area designated in the proclamation all police powers vested in the state of Oregon, Oregon Constitution in order to effectuate the purposes. And the sub 2 says, during the state of emergency, the governor has authority to suspend provisions of any order or rule of a state agency if the governor declares the strict compliance with the provisions of the order or rule would in any way prevent, hinder, or delay mitigation of the effects of the emergency. That being said, we noted that there was an absence of the word statute there. And that was our concern. We thought about trying to shoehorn another provision that says that the governor can overrule laws, ordinances. Don't remember the exact wording, but we were not comfortable with going down that road in light that there may be a challenge to a document 20 years down the road, like a deed or something like that. And that really made at least title company lawyers uncomfortable. But the rest of us kind of agreed that a court may well apply the PGE and its progeny to say it's not there in the statute, so the governor didn't have the authority to do that. We wanted to leave that alone.
Let me ask any of our, I just want to ask if Lorianne or Marisa or Chantel, for that matter, if either of you have an opinion on this question.
I agreed with what Mark said about whether we can do this by executive order. I agreed with what he said exactly.
Okay. And do those same considerations that were that you discussed relative to the remote notarization statute, would those same considerations apply to adoption of something like the language we have in this proposal before us today?
Lorianne, does it? I mean, it's a statutory change, right?
Yeah. Okay. That was sort of a leading question.
Before we leave this topic, this is Matt Schrumpf. Was there any discussion of ORS 433.441 that governs governor's authority in the context of specifically a public health emergency? And paragraph 3F authorizes the governor to take any other action that may be necessary for the management of resources or to protect the public during a public health emergency, including any actions authorized under, and then it cites several statutes in Chapter 401. Was that part of the discussion?
The specific part of the specific reference to that statute, we didn't get into it that close because there was the, I guess, concern that really there is not an emergency that means you can't be within the same proximity. The example was someone can sign a deed on the front hood of a car, and the notary could be on the standing at the rear end of the car watching what occurs, and then trade documents or trade positions and execute. That would be sufficient proximity. Another example was you could see it through a window and or use kind of like a teller drawer to execute the document. So we said, well, it's a hindrance, but it's not truly a full emergency. So that's just how that work group came down on it.
Okay. Anybody else? Well, I'm just, I want to take the temperature of the group then. And I said this would be iterative, so I'm iterating. Do we have enough confidence, number one, in process to be able to present this to the governor as a possible executive action? And if we do, then I think it merits working through it, at least to try to achieve a level of comfort among our group with what we're proposing. If we don't have that level of confidence to be able, that we could present this to the governor for executive action, then I think we're back to what Susan, where Susan was, that that once we have the remote notarization, we've accomplished most of the problem. And when you couple that with the harmless error statute, that seems to cover most of the rest of it, with procedures in place for how that gets proved in court, to get back to Judge Donnelly's concern. And so where does that take us? I'd like to hear some discussion about that.
Lane, this is Matt Schrumpf again. I'm not going, even though I am at DOJ, I'm not going to, I'm not in the position to advocate to say that that statute that I just referenced gives the governor the power. I just was aware of it and
sure.
Wanted to know if that had been part of the discussion. So I'm not proposing that we rehash the discussion that the other work group may have had yesterday, and sounds like there were concerns about that approach anyhow. And as to the other statutes that are either being considered or are in place, remote or e-wills and remote notarization legislation and the harmless error statute, just for a question about the scope of this, I had noted earlier advanced directives and mental health directives under Chapter 127 can be notarized, but are also documents that can be executed just with 2 witnesses. And so those would not, if the witnessing aspect of them would not be accomplished by the e-wills or harmless error statutes. And so if the remote notarization was enacted, that would allow one means of completing those, but not the other. I don't know if that's a big enough concern for us.
Okay. Well, let me ask, in light of this conversation, it's been a great conversation, is there a sense in the group that we want to push through this? Or, is the consensus of the group that there are enough issues around the substance of the proposal that, coupled with the issues around authority of the governor to implement this by executive action before we get to legislative action, that we just say, thanks, we've looked at this and we determined that it's not ready for prime time.
Hi, this is Eric. There's a clamoring for some kind of adjustment. And I know that it would have to wait for legislative approval or the governor speaking out. And I think showing some form of action would be beneficial as opposed to not taking anything. I mean, we'll never necessarily have a perfect bill, and there's always going to be some nefarious actions out there. But I think we need to have something out there, because we're finding practitioners who are kind of creating the wheel on their own, which is probably going to cause more problems down the road, or people who are relying on harmless error when it's, how is it really an error if you're intentionally doing it? It's more of a harmless circumstance situation. So I think we're better off having something in place as opposed to nothing.
This is Judge Cobb, and actually harmless error is kind of a misnomer. It's called exceptions to the will execution formalities. And at least from, I think from a court perspective, under 112-238, the court has, I mean, there's notice that's required ahead of time. The court has a standard of clear and convincing evidence. There's directions here as opposed to what I'm looking at, and my concern is, what am I supposed to be applying here? As Judge Donahue was talking about, is it going to be an affidavit sufficient? Is it, what exactly am I looking at here? The other thing that concerns me about the proposed, I'll call it the Kentucky legislation, is when you couple that with the harmless error 112-238, are we going to have both of those that the court is trying to look at and apply? I'm not sure. I think that using 112-238 during this time, I think that addresses the concerns, at least with regard to the execution of wills and the exceptions and what the courts are supposed to be looking at.
Let me ask, who's that? Nobody?
This is Gretchen.
Yeah, Gretchen.
I was wondering if that would be applied, Judge Cobb, consistently by the judges in the different counties. I know that's always been one of our goals, is to have something that's consistent. And so will they be able to look at the, in quotes, harmless error statute, and will judges look at it the same way? Or is there something that would help in that if it had a little more process written into it?
Well, I mean, we've already got a Court of Appeals case that's directing to the court, and, I can't guarantee what judges are going to be doing. I think a lot of it is going to be what the advocates are saying. I'm just saying having direction for the courts and what they're supposed to be looking at, as opposed to somehow everybody appeared via to electronic video communication, and what am I supposed to be doing is with regard to that as far as proof.
Well, I agree. If we would go forward with those that we would need. Sorry.
Eric, did your daughter just give you the answer?
She did. She was wondering about what was lunch. So.
Okay. I'm sorry, who did I cut off?
No, it was just Gretchen, and I understand exactly where Judge Cobb is coming from. I'm just wondering then if there were more process put into this proposal, if that would alleviate the concerns. I'm not taking a position one way or the other on it. I'm just curious if that would help more guidance for the judges in this
Let me
proposal.
ask, maybe in terms of wills anyway, the more we put into this, the more it begins to look like the harmless error statute, which already has those the processes and the considerations built into it. Let me ask our commissioners, since I'm not on the law commission anymore, and Sandy and PK, if you're with us, Mark, how strong a directive from the commission is this to do this, or was it to did you just want it to be evaluated and yeah? So how strong is the direction from the commission on this?
Lane, this is PK. I don't think that there is a mandate from the commission whatsoever to push this through. It really is to evaluate it and be, I think, a thought partner for the governor's office in that. The governor's office is hearing a lot of things that they're hoping that people can do. And I think that we can be a good convener to bring people together. But if we don't think that this is the right time or the right way to do it, nobody wants to do something that's going to just fall apart later on, right? So we need to wait for the right time and do it in the right way.
Thank you. Oh, John.
So I think my worry about this is that by the time it gets enacted, it'll be too late to do anybody any good. But that doesn't mean we shouldn't do it. It doesn't sound like the governor's going to do it with an executive order, but maybe she will if we if we draft this, and it's something that could easily go into an order if she chooses to do so, then that might be helpful. I'm reluctant to rely on harmless error. You know, I know it's really useful. It's a great provision to have, but to intentionally disregard the statutory requirements and then assume that you can excuse that by it not being meaningful is risky.
But John,
And it's
doesn't this create that same question with even less with even less process and protection?
Well, no, this creates the process. So if we enacted a statute like this and the requirements of the statute were met, then you would have a properly executed will. You wouldn't need to go through a hearing to have a judge determine that the will was properly executed, which is what we have right now with harmless error.
Well, are you suggesting that a will, for instance, drafted under this language should be a self-proving will? I see that as being a pretty high hurdle.
It could be. I mean, if this, I don't see why it wouldn't, because if you have this, if you have this in the statute and it's complied with, then you've got the presence requirement. You don't have to have a court determination that the statute was met. You know, you self-prove it. You could admit it ex parte. A contest could come later if somebody wanted to. But what I find to be really problematic is relying upon court determinations to validate something, because in today's environment, that adds incredible amounts of time. You want to get a probate opened. You don't want to screw around noticing everybody, having a hearing, and trying to convince a judge that the harmless error statute applies. And when you can't even have a hearing these days because of the social distancing requirements, how do you even get the process started? I think it would be real beneficial to the public to be able to get a will done, signed, and have it be effective with remote attestation, and just be able to get a process started. If there are problems, Brooks can take care of those in the will contest. You can always challenge all this stuff. There's no, you still get to litigate if you want to. You can quibble about how properly done or not.
Brooks, I think he's late. I think he's thrown down the gauntlet for you.
I just said hooray.
But this is Judge Cobb, and the reality of the situation is the damage that a personal representative who is appointed, if this becomes a self-proving issue, and the will is admitted to probate automatically, the personal representative is appointed. Down the road, the objections occur, the will contest occurs. I think everybody knows how long that process takes and the damage that a personal representative can do. You give me 2 weeks, I can create havoc in an estate. And it's our intent of self.
And you give me 2 weeks or 2 months, John, and you give me 2 weeks or 2 months or 6 months of nobody being authorized to administer the decedent's affairs, and there's far more damage caused by that.
This is Jennifer, and I have 2 points to make. First, I think under the harmless error statute, you could easily, if nobody objects, have consents, present written evidence to the court, present draft findings of fact, and comply with the statute, and have the probate opened within the same amount of time that it normally could. If there's no, if everyone's on the same page, which in a lot of the estates that I'm dealing with right now, that's the situation. And then the other point that you had made, John, I'm sorry, I lost my train, but I think that it can be done quickly.
Well, that's wonderful, but that's not been my experience. Things don't happen quickly.
It just seems incongruous to me that you would have we'll call it harmless error, although we do recognize that that's really not what the statute is. It's the alternative process. But it does seem a little bit incongruous to me that you would have a harmless error statute that creates the process by which it is proved just because it was executed in unconventional means. But here we have something that involves even less in terms of requirements to validate and no court process to confirm that those circumstances existed when the will was proved or was signed.
This is Heather Gilmore. I've just been typing into the group chat, but I wanted to say what we're talking about is remote witnessing. That seems to be the focus of our conversation. And just because the witnesses aren't physically in the presence of the testator doesn't mean that anything else changes. They still have to sign the affidavit of attesting witness, swearing that they believe the testator had capacity, that the testator wasn't acting under undue influence, that the testator understood it with the will. So all of those factors remain the same. The only thing that this statute does is remove the requirement to be in the physical presence of the testator. And I appreciate Jennifer's point about we don't know what happens in the video conversation before everybody joins it, but neither do we know often what happens in the car ride to and from the lawyer's office, nor do we know what happened at home, before they left. So it's, when we're balancing things, all we're doing is removing the physical presence of the witness component.
Okay. That's helpful. That's helpful. That kind of reground us in the focus of this. Of course,
this is Lorianne.
Lorianne.
Can I make one point?
Yeah.
In addition, I think it'd be helpful to expand this conversation because this provision, the proposed provision, doesn't just apply to the witnessing of wills.
Right.
It would apply also to, for example, an advance directive. And your execution of the advance directive would not have the fallback of the ORS 112-238 or something similar. So if you're wanting it to expand, if you want it to apply to those types of documents, then we really should have the checks and balances in this provision that you would want to apply to all the documents, not just to.
Okay. All right. Well, I tell you what, we have an hour of our time. Let's use it. Let's suspend disbelief for right now and approach this as a draft, and we may learn to love it as we go through it. As you can tell, I'm open to any outcome here, so I'm not trying to force anything here, but I think in good faith to the ask to look at this and to advise both the governor and the legislature. Let's take a look at this, see what we can create with these concerns and considerations in mind, and decide when we get done if we're close to having something that we could learn to love. So with that, let's start with section 1. And this is for the purpose of complying with any law, rule, order, or other requirement relating to the receipt. Wait a second.
There's a missing word.
Yeah. Lorianne, was that the typo you saw?
That is the typo I saw.
That would be receipt of a signature? Or what?
Yes, sorry about that.
Okay. From any party or witness, or the acknowledgement or notarization of any document for any legal purpose. Okay, let's parse that. We're going to take out notarization. Is acknowledgement, does that go hand in hand with notarization? Are they severable for the purpose of a bill like this?
Before
you
we
acknowledge
get
it
into
with a
the
notary?
words, can I ask a larger question? Is
What?
there a reason why we're trying to approach this through its own special weird little clause instead of just taking the remote presence or the electronic presence provisions that have already been created for the e-wills act and trying to apply them more broadly? Because those are much better written provisions than this and include their own commentary and additional pieces for how they should be applied and why they were created the way they were, that would help address some of the concerns that have been brought up by my assorted colleagues on the commission.
So Susan, that's a question, I guess. Can we create a mini e-wills statute? Or once we get into it, are we really into it for the whole, the full deal?
So the reason I hadn't thought about that, but I'd have to look at the statute in the eWills Act. If the attestation is remote, then remote online notarization is required in order to make the will self-proving. But we're saying here with this, we're taking notarization out, so the will is not going to be self-proving anyway. The eWills Act would make a will valid with remote attestation. It just wouldn't be self-proving. So yeah, maybe we could look at that.
Well, except in going back to Lori Ann's comments, the eWill, well, okay, but it would need to apply to other documents besides wills.
Well, right.
Right, and so.
Oh, Chris, you muted. Chris, you hit the mute button.
Hey, Lane.
Sorry,
let's let Chris
playing weird games.
finish his thought there.
But my suggestion would just be we go to the eWills Act, we lift the definition of electronic presence, and we put a bill that basically says wherever the presence of a witness is required, electronic presence as defined here meets that presence requirement for purposes of witnessing whatever. Obviously, you can draft it with.
Oh yeah, that's an interesting, that's helpful. Ken.
Well, I'm just thinking we're going to have a meeting on the 23rd, and I understand that we'll be looking at that time at both the remote notarization and the electronic wills in preparation for a legislative session that may happen around the end of May.
Right.
If we're now talking in this meeting about a third proposal that would accomplish, it seems to me that there would be a considerable overlap between what we're talking about this morning and the Electronic Wills Act, and that maybe we're wasting our time. If we've already got two bills that are potentially out there, why do we need to consider and construct a third?
And I think the only, that's a good question. One answer to that would be, and I think there's a high degree of skepticism whether the governor could implement this by executive order before the special session. And the other would be, what about documents other than wills? And then we're talking about, advanced directives, mental health directives. And I guess then the question is that a big enough universe of things that we're concerned about that need emergency relief?
Well, and the advanced directive can be either notarized, or it can be either notarized or witnessed. And so that will be taken care of with the remote notarization piece.
Right.
And I don't think of any other documents. There probably are some that are witnessed, but not notarized.
A remote notary is far less accessible than two witnesses via electronic call or whatever other provision we want to put in for witnessing. Not even all actual present notaries qualify for remote or e-notarization.
Right.
Lane, I wanted to bring up, and Susan might be more appropriate to speak on this, but I know that there was some reluctance to try to push e-wills forward so quickly. I know we were going to discuss it at the meeting next week, but I know that it is a relatively novel concept, and we knew that there would be, whether there'd be opposition to it, but there would certainly be a lot of items for pretty in-depth discussion. So I want to make sure that we're all had that.
Right, and that was my initial thought. I think the views on the usefulness of electronic wills may have changed a lot over the past few weeks. We have seen reasons that I think in most circumstances people won't be using electronic wills, and that's likely to be the case. But there are some circumstances where electronic wills are useful, and I think we're now seeing a reason that they may be useful. So I expect it to be a different kind of discussion.
So Lori Ann has just put on the chat the definition of electronic presence from the eWills Act. And that means the relationship of two or more individuals in locations communicating in real time to the same extent as if the individuals were physically present in the same location. So I guess the question, maybe Chris, going back to yours, is could we do something like that with this language, with this bill, that doesn't apply exclusively to wills, that incorporates other documents that require witnesses, the presence of witnesses to attest, and just get that much in ahead of prospectively the e-will. So it's a much, I think, yeah, so that, I guess that's my question. Could we approach this not from the Kentucky direction, but incorporating this concept of electronic presence broadly wherever presence of witnesses are required to attest to a document, and excluding notarization?
Lane, this is Mark. I think that is really the standard that's set forth in sub 1 of the proposed language. And if we're taking out notarization, I think we're there.
Okay.
So Lane, this is
one of the biggest benefits.
Oh, yeah, please.
Just a point of clarification. I think an acknowledgement is a form of notarization. The notaries usually are either taking an acknowledgement, which is what's necessary for a deed, or a jurat, which is what the notary would sign for an affidavit. So I think there would, if we're going down this route, it'd have to be a clarification about what notarial acts are we really referring to here. Notarization is just the generic term for notarial acts, and if you get down to the specifics, you talk about acknowledgements and jurats.
Well, on that same point, if this language is intended to not allow remote notarization because that's going to be dealt with in a separate statute, should this maybe expressly exclude notarial acts?
Yeah, thanks, Matt. We had actually talked about that.
Not just removing the phrase notarization, but saying excluding notarial acts.
Right.
This is Jennifer, and one of the ways of witnessing an advance directive is to have the person acknowledge the signature, and so we do want to not exclude that.
Okay, so but maybe putting your comment, Jennifer, with Matt's, we could leave acknowledgement in, but then add an express exclusion of notarial acts. And so the kind of acknowledgement that you just described would be covered within the within this statute, but to the extent that it might require a notarial act, it would not be. So let's just try this then. We'll delete or notarization. And let's look at number 1, because that does get us close to this electronic presence definition.
And before you go to 1, can I make a comment on the introductory stuff?
Yeah, sure.
This entire, the beginning of this kind of focuses the entire provision on the receipt of a signature.
Right.
And I have no idea what that means. I don't know what the receipt of a signature is. That's why I don't think it covers an attestation. It just deals with a signature. So I think we ought to get away from that language. And I think it should be, and I think we ought to be kind of clear in this, because I think we're better off trying to do something specific than trying to do something broad and general.
Okay.
I think we ought to say that this, for purposes of will attestations, witnessing advance directives, and if we want to, and any other act that requires the signature of a witness.
Lorianne?
Yeah, so thanks, John. So one of the things that I considered was whether we should have it mirror ORS 42030, which is regarding subscribing witnesses. So that provision says that a subscribing witness is one who sees a writing executed or hears it acknowledged and at the request of the party thereupon signs the person's name as witness. That we could mirror this language to, or we could craft this language to kind of mirror that, so that it would be, sorry, let me open up that screen again. So for the purpose of, you know, witnessing a document under sorry, trying to wordsmith.
Yeah.
While talking.
No, I get it. I get it. That's a great approach.
So it's, instead of having it be that it's the requirement relating to the receipt of a signature, it would go more toward a person may witness a document in this manner, and have it kind of track that 42030. Would that work with what you're talking about, John?
Yeah, I think, but I'd like to have a cross-reference to the attestation statute and the witnessing of advanced directives, and then you can have a catch-all afterwards if you really want to. But I want to make it, I think it would be helpful to aim this at those two estate planning documents that we're also concerned about.
Okay, that aside, I think I really do like Lorianne's suggestion that we, and what I like that is that it frames this within the structure of Oregon law already. We've got this bucket of documents already defined that require this kind of witness or attestation or acknowledgement. And rather than creating a new description of those things, we incorporate that, or we use it in this. And then John, I guess your question is if you want to add a including and some of those and a couple of those specific things, that may be an LC question. We can look at that as well. But let me propose that as an accepted suggestion for a redraft of this to look at next week. That the preamble be mirrored more on what Lori described, and not this new language that requires new interpretation and maybe overbroad or under-inclusive at the same time. Lori, Andy, are you comfortable with trying something like that?
Yeah, I'm fine with that.
Okay, so let's go on to sub 1 then and see what this does with basically electronic presence. And keep in mind that it's still up on the chat bar, the sidebar, the definition of electronic presence that Lorianne put up there. So let's look at these together. But in the draft we have individuals who are not in the same physical location shall be considered in the presence of one another if the individuals can communicate by two-way electronic video communication. I think we want to include audio if we use this language that allows the individuals to communicate in real time to the same extent as if the individuals were physically present in the same location. Do we like that better, or does the electronic presence definition accomplish the same thing?
The electronic presence definition works better because it does not provide inherent discrimination against people who can't use video or for some other disability related reason have issues with whatever preferred mechanism we're going to pick. Whereas just stating it has to be in real time to the extent they were physically present in the same location gives us the ability to adapt to whatever accommodations are reasonably necessary for an individual. And I mean, less important in this context, but it also allows for future alterations and advancements in technology so that we don't pin ourselves to, dot matrix printers.
Good.
Elaine, can I make a picky comment?
John, you?
One of the limitations of this type of communication is that two people can't both speak at the same time as they can when they are in person. So that might not be equal.
Oh, that may be reading it a little more narrowly than I think it's intended.
Of course.
But I think the intent of that is valid, and that is to ensure that this electronic communication be real, as much like communicating in the same physical presence as possible. If we needed a comment, I'm sure Susan could craft one that says, that's not intended to be interpreted quite that literally or narrowly.
Yes, if I can add there, we had a discussion on the Electronic Wills Drafting Committee about the possibility that there would be a fraction of a second delay as there was between the space station, and it just got crazy. So I think we can deal with that in a
We've
comment.
already solved that problem. Okay.
But I do think, I like the idea of using the language from Electronic Wills, because it does, the couple things that were mentioned are both things that we talked about in that drafting committee. And one that's important is to make accommodations. We didn't put accommodations in the Electronic Wills Act. We're just relying on, the same as to address any accommodations that that there might be. So I think it does that well.
Okay.
Lane, 1 second. This is Sandy. Just really quick. I want to, for those of you who are not on the Zoom computer, I did just send the draft of the e-wills that Lorianne had put together for our meeting next week. I was holding off till after the meeting to avoid confusion, but you now should have it in your email.
Okay, thanks. I am going to declare a consensus on at least the sense of the group that we incorporate language more like the e-wills language, defining electronic presence. And another reason to do that, and it just piggybacks off of what you just said, Susan, is that you also have commentary, I assume, in the e-wills that we could either incorporate as commentary as comment to this statute, or at least there would be a clear reference to this language and the comments that underlie it in the Uniform Act.
Right.
And that would take advantage then of all of that nitty conversation that has already occurred about what this means to be same extent. All right. So let's assume that we've solved number one. We have defined and we acknowledge the concept of electronic presence. Then we go to number two. Any document resulting from a two-way electronic video communication, well, we'd have to make sure that corresponds then to what we do with number one, in accordance with subsection 1, may be executed, acknowledged, we take out notarized, in counterparts, which together shall be considered a single document. And I assume that is to get exactly at the comment that somebody made earlier, that you're not, these folks are not signing the same piece of paper. Any comments on that?
Yeah, Lane, this is John. What I've read that's been a issue in other states is that the concept's fine, that you sign separate pieces of paper and you put them all together and you got one document. But what the issue in other states has been, how do you transmit the documents? Is it enough for the remote witness to send the signature page to whoever adds that to the document the testator signed, or do you have to transmit the entire document in both directions? And the mechanics of it are the issue. And it's problematic. They're having a fairly intense discussion about that in New York at the moment. Do you have to transmit a whole 60-page long will just because you signed the last page?
But if you don't, how do you know that it's the same document that was attested or witnessed?
Well, that's the issue.
Yeah.
That's the issue. Yeah. So I think the way we do this with contracts, where we sign in counterparts like this, is we just send signature pages around.
Right.
And somebody attaches all the signature pages at the end. So that's what counterpart execution of a contract is typically thought to be. So we ought to address it,
yeah,
I think, one way or the other.
John, I agree that's the practice for assembling a contract, certainly. But if there became a dispute, if a contract was presented with signature pages and one of the signatories says, that's not the contract that I signed,
right,
then each party would be going back to show, here's the contract I received by email from so-and-so, and that I then signed. And so I think they do need to at least be receiving, each party needs to have the full document at the time that they're signing it, and including the witnesses who are saying, you know, I'm witnessing that testator is signing this document.
And then,
I'm okay
and then
with
Matt,
that.
or anybody, do those multiple versions of the same document with different signatures on each, do they then have to come together to constitute the original document? It seems like they'd have to.
This is Jennifer. Maybe it would work to have somebody do a declaration with the completed document with all the counterparts compiled that just says, I declare that I've seen all of these signed documents, and this one compilation reflects an accurate signing of the document, or something like that.
Okay.
Yeah, and this is Judge Donahue.
Judge Donahue.
This is Judge Donahue. I think that may go back to the declaration certification that I was referencing earlier. And we may be, and one way, again, just from the court's perspective as to what we're getting and seeing, if there was a declaration describing that on this date and this time, these parties were reviewing this document that both acknowledged during the video conference were identical, and during that conference executed in the counterparts attached to the original document, that may address that issue, at least as far as getting over that initial hurdle of litigation based on, well, this wasn't what I signed.
Okay. Yeah.
We get that declaration.
This is Gretchen. And usually, I mean, we have standard contract language regarding counterparts, that the contract may be executed in several counterparts, all of which are taken together. That language is in every contract. So, you know, having something along those lines might be helpful.
I think what Judge Donahue is suggesting goes beyond that to certify that, because I think Matt raised the issue correctly or appropriately, that if there's a dispute as to, if someone says, no, that's not the contract I signed, then they're alive to show what it was that they signed, and that it's different than the counterpart that's been presented. We need something a little bit more protective here because we're dealing with a deceased. Well, we may be anyway, not in every case, but I like the idea of some sort of a declaration like that. Lorianne, you were wanting it a little bit before.
Yeah, so I'm curious how that would work in practice. Who would be the one signing this declaration?
I was just going to ask that. So let's create the scenario. We have the person signing, and let's say it's not a will. Let's say it's an advance directive. They're signing their advance directive, and I'm signing it, and Susan is on Zoom with me, and so is Ken. And I've read them, I guess, the document that I'm signing. We've discussed it. They're satisfied that that what they have in front of them is the same thing that I've got. And I sign, and Ken and Susan sign, and yeah, then what happens?
Hi, this is Marissa. I just wanted to jump in on Lane's what your scenario is. So in that case, would the person be at home? They would complete their advance directive, they would have all their initials done, and then they would send it out to a group of people to then have it witnessed?
Well, that's a good question. Yeah, I'm not sure. We're figuring this out.
They just, at that point, it doesn't seem that practical or easy for most people who are wanting to complete a medical document during this time.
Right.
I would think it would be similar to what we do in person, and it would just be your remote witnesses watching you do your initialing and then sign.
But if in the physical presence, they watch me sign and I hand them the document, they know that they're witnessing the same document I signed because they saw me sign it and there's my signature. If you are in electronic presence, you don't have that immediacy and certain knowledge that you're witnessing the same document that you're watching the person sign, right?
So I email you my advance directive.
Right.
I tell you, print this out or
right.
Look at this. I am now on page 2.
Right.
I am initialing next to other instructions. It says blah, 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 blah.
Right.
I am now on page 3. I am initialing under paragraph capital A. I do not want life support. Whatever. I am now at additional instructions on page 4. It says blah,
right,
blah,
right, right. Yep.
And I sign. I show you on my webcam. Here's my initials. Here's my other initials. Here's my signature. Please witness.
And I've got a copy of, what do I have as the witness? What do I have in front of me? Is it the complete document?
You have the document and the signature page, and
right.
you signing on the witness spot on the signature page, just like we would if we were doing a contract or something similar in counterparts.
Okay.
Well, this is Jennifer. And again, remember that we have the ability to just simply acknowledge, have the person who signs the advance directive acknowledge that it is their signature. So I think all they would have to do is say, here's my advance directive, here's my signature, you can see it's dated today. And I think that would be enough.
Lorianne. Oh. No. Okay.
John here.
Susan, did this come up in e-wills? No, because you've got a lot more bells and whistles.
Right, and also the document itself is electronic, so
right.
we didn't have to deal with counterparts.
Right.
There may be multiple electronic wills, which we did have to deal with.
Hey, Lane.
Yeah.
I started this not having an opinion about what the answer ought to be, but I
Same with me.
I think, since this is really just a short-term mechanism, I think probably the easiest thing to do is require each of the parties to execute a complete document and assemble all 3 complete documents to make it one original.
Well, that's kind of where I was starting from.
Yeah, I mean, as much as it's so much easier to just assemble signature pages, it might be cleaner to just have everybody get a full copy of the document, and you're going to have 3
right.
testator witnesses, so you just have 3 copies of the same will, and that way you can always look and see if they're the same, and it can be determined later. The declaration, I think, is a great idea, but when you start thinking in terms of the declaration's probably going to come from the testator, possibly. You can't, a declaration signed by somebody who's not alive to testify about it might be of limited use. But I know I saw Melissa had made a suggestion that you just have the document state that it was executed in compliance with this procedure, and then everybody knows what's going on.
So in terms of mechanics, Do we agree that the witnesses and the person signing should have a complete copy of the same document? You know, and I guess let me ask you, that raises a problem, because sometimes you may have somebody who wants their signature witnessed, but they may not want everyone to know what's in that document. Does that create a problem here if we make that a requirement? Anybody?
Well, I can tell you.
Well, this is
as
Judge
far as-
Donahue. I think there's two different issues here. One is sub B is only for documents that require signatures with counterparts. If you had something like a will, the witnesses never signed the will, so there would be no counterpart to the will. It would be only the witness attestation page that they saw the testator signing the document.
Witnesses 100% sign the will.
Well, they would sign, but they attest, the witnesses that you're talking about, I thought we were talking about the attestation. That they saw them.
Right, the witnesses sign the will and they sign the affidavit.
Right.
Well, wait, the affidavit though is that's for the self-proving affidavit, correct?
Yes.
You're talking about a witness signing the will. And the witnesses, I think we would just ask, does the witness need to sign, because we're talking about two things, a self-proving affidavit and then the will itself.
Yeah, I'm not so concerned about the affidavit, because the witnesses, at least in the context of a will, can sign the affidavit anytime.
Right.
But their signatures on the will need to be contemporaneous.
Correct.
And in the presence.
Right.
So, and we're not just talking wills, we're talking advanced directives. I mean, how important, okay, let's back up. How important is it that the witnesses be sure that they are witnessing the same document that the person executing the document is witnessing? Or do we just take that on faith?
Well, I guess this was my point. I mean, we go back to the things we've been talking about is somebody, essentially all the witnesses is witnessing in a will, not the self-proving affidavit or anything. All the witnesses witnessing in the will is the person signed a document. That's all the witness is signing when they sign the will. They're just witnessing a person signing a piece of paper. This isn't like a contract where they're binding themselves to anything for a will. So there's no real, they're not executing it. They're just witnessing the person put their signature on that page at that particular date and time in that particular county. I don't know if that's a counterpart issue, is it?
But then their signature needs to be attached somehow ultimately to that original document. So that's
correct, but it would, right. No, I agree, but again, I don't know if that's a counterpart issue, if that's just, they need to have the signature, the witness signature needs to be attached to, it would seem like they would only need their witness for wills only. Their witness signature would only need to be attached to that page that they witnessed the person signing.
Right. So let's walk this through. Let's set this up. And okay, it's a will. So I'm signing my will. You're watching me sign my will, and below my signature is the statement of the witnesses that, not the attestation, not the affidavit, but just the statement of the witnesses that, I saw the person sign this will and I'm signing my name too. For electronic presence and for the validity of that witnessing, what do they have to have in front of them? If Susan and Ken are witnessing my signature, is it enough that they sign just that signature page and send that back? Or, we're making a policy call here because it's really not addressed in this language. In order to validate their signatures as witnesses, do we have to have them, do they have to have the complete document that I'm also signing? Do they need to witness, do they need to sign as witnesses on a complete copy of the same document that I'm signing, or can they sign just a signature page?
So this is Judge Cobb. Isn't the difference between this and a contract, say, is that if it becomes an issue, the decedent, the testator, cannot testify. The testator is now dead.
Right.
But currently, this is Marissa, currently if someone signs their will, they don't have to show people what's in it. And so that's my concern, is that I think it's enough that someone remotely, I could say, I'm Marissa, I'm telling you witnesses that this is the document I'm signing. Witness then says, I saw her sign a document that she said was this. And it's not that different than now. I don't think we should be adding additional hurdles that aren't required.
But again, isn't the hurdle, and maybe I'm just overthinking this myself, but isn't the hurdle that if in the physical presence, I don't care what's in the will, I'm the witness, I've seen you sign it, I'm sitting next to you, I take that same page and I sign it too. There's no question that I'm signing the same document, that I'm witnessing the same document that I saw you sign. That's not the case in an electronic transaction where I'm signing a page, a document, but I don't know for a fact that I'm witnessing the very same thing that you're signing.
Lane, this is Mark. In the electronic environment, I doubt you're going to even have a signature on a physical signature. You may have a mouse click on that is associated with a document. So I think we're getting bogged down in some physical aspects of a document that aren't really going to be present.
So you think we don't need any language to address this?
Well, I think that we need to think about this. Okay, if the testator is indicating his approval of this, whether it's by signature or something else, the witness can do a similar thing by associating a mouse click with this electronic document. So I think the electronic document then is proved by the electronic association with the electronic document.
This is Judge Cobb. I'm confused now because we don't have e-wills.
Right.
So is assuming that these wills are all electronic now? I thought we were talking about an actual physical document.
No, and if I can add, I think, yeah, we started to mix things.
Yeah.
But even if we have paper, remember that how we've defined presence to include something that replicates presence, and we took out the audio visual, but in most circumstances, that's what it will be. We've taken it out to allow for adjustments for disability, but in most circumstances, particularly under these circumstances, I will be able to see. So if I am observing, if Lane, you're signing your document, I see you sign it, I sign a piece of paper, and it can be a physical piece of paper that says,
Right.
I saw Lane sign his document. My piece of paper is then attached to your document. That seems to me to be enough. And one of the things, and John mentioned this earlier, one of the things that we could consider is including a requirement that this process be supervised by a lawyer. Some states have done that. I did a little looking to see if I could find the states, and I haven't tracked it down. But we could require, because part of what we're concerned about is people switching things. I know that generally we don't like to put requirements that people use lawyers into the statute. So we may or may not want to do that, but some states have done that.
And this is Judge Cobb again. I guess my concern is that you're watching Lane sign something, and how do you know, Susan, whether there is anything attached to that one piece of paper that you see him sign?
or you know that there is, but you don't have it. The rest of the will.
Right. And now Lane's dead. Sorry, Lane, you're dead. And the question becomes, what was it that Lane signed? Because Susan says one thing, and I forgot who your other witness was.
Ken.
And the other witness says something else. And I mean, the mechanics are what are confusing me, and how we're going to actually be looking at this. Maybe Susan's idea or John's, whoever idea, was about having an attorney supervise this, so that there would be hopefully some consistency and compliance with some standard that the court could be looking at.
And this is Judge Donahue, and this is, I think, maybe what I was inartfully trying to capture earlier in the declaration. And I think this is not going to be perfect, and I'm just looking at it again from the court's perspective of what we'd be looking at just to determine whether there was compliance with this legislation, with this statute, or this whatever it is. And it would seem like if there was a declaration by, say, the testator that was attached to the will that said, on this date and this time, I had a full copy of the will, and that these people were present by video and audio communication. I signed this copy of the will. They witnessed it. They signed it. Then the testator signs it, and those two witness sheets are attached to it. I think, and I'm not, and as far as legal effect or whether it's going to be challenged later, that's not the issue. The issue is from the purpose of the court or someone looking at that document, confirmation that the electronic signature requirement was met. I think that would be the best we'd be able to do, but I think that would at least address any questions that we would have as far as, was there compliance with this statute or rule or order or whatever it's going to be at the time the signature occurred.
This is Judge Cobb. So then we are specifically excluding the 112-238, which we've nicknamed the harmless error rule?
I don't think so, because the harmless error rule would then apply if somebody said, well, I was, there may be some issues with what occurred, which is, well, I had something to deal with my kids, so I didn't, one of the persons on the line says, I was there, but I got distracted. I didn't see them sign it. So it didn't count. I think you'd have a harmless error rule argument there. And again, I'm a judge. I can't make, the harmless error rule doesn't, we're looking at whether, the harmless error rule is whether there was problems with the form, and should that problem with the form create, invalidate the will, or should it be accepted? This is more of a question of, this I guess goes back to did the person validly sign a document? And that's different than harmless error to some extent. The harmless error is the form of this thing is not a will, and the harmless error rule is, well, it's a person who wrote something on a cocktail napkin with their name on it. It satisfies the requirements of a will under the harmless error doctrine. Those are two different things a little bit.
You could have a failure to comply with this statute, you would still be able to offer a will under the harmless error. I mean, it didn't comply with this for some reason. There was some technical non-compliance, but you have other evidence to indicate that it was intended to be the testator's will. So yeah, I think these do have some interplay, but they don't overlap, and they're not. Yeah, one doesn't subsume the other. But let's talk about this, because I think we need to see it in the next draft. So are we back to what Marissa was advocating, that the witnesses don't need to have the complete document, but maybe what we have is some special attestation that the person executing the document, and I would say testator, but it won't always be the testator. Maybe if it's electronic presence, we need to have a particular statement that the testator or the person signing the document, they're the one who's certifying that these people were in their electronic presence. And then that attached witness page is all that they need to, that separate witness page is all they need to attach to the document to validate it, at least facially, under this statute. Does that work?
Yeah, Elaine, it's John.
Yeah.
Can I chime in?
Yeah, you bet.
I see those as alternatives. You could either, you know, have everybody have the same document and sign the same document, and then you can see for yourself that they were all the same. Or if we have Judge Donahue's declaration procedure, then all you need to do is send signature pages around if you have that declaration. So to me, you can go, they both work.
Okay.
This is Jennifer.
And if you want, I suppose you can give alternative. You can make them both alternatives as well, I suppose.
Sure. Let me get Lori and Lorianne and then Jennifer. Lorianne?
Yeah, I like that idea, but I have a question about, well, what if they go through this process and they pass away before they're able to obtain the signatures to do this declaration that they would attach the signatures to? Does that make sense?
Yeah.
Well, I guess that goes back to, is the declaration that the testator, assuming it's a will, but the testator would be signing, is that signed after they receive the physical copies of the document with the signatures of the witnesses?
I guess I would say no.
Or would it be done contemporaneously with the execution of the will?
In my thinking, it would, and that would solve your problem. Because you're saying who you've asked to witness, there'd be the date, and you know, of it. And as long as those witness pages then correspond to what you have attested, you being the person signing the document, correspond to your description of them in your attestation, then I think the problem is solved.
Okay.
Jennifer.
Well, I like the idea that Judge Donahue has about the declaration, but I also think it might be useful, and this could also address the concern Lorianne had, if you could say either the testator signed that declaration or a lawyer who was an attesting witness. I suppose you could just even have it be another attesting witness.
Come again?
Well, you know, I could see the situation being that the lawyer is the one who compiles the signatures, prepares a declaration, and submits it to the court, rather than the testator be the one to compile the signatures. And so I would like to have it not limited to the testator of saying, because the declaration needs to say, here is the packet. It is the signed document by the testator and the 2 signed witness pages, assuming they're separate. And so I'd like it not to be limited to the testator to be the person to make that declaration that those documents have been assembled.
And maybe we're talking about 2 different things here. One is that the testator declares, or the person signing the document declares that they have asked, that I've asked Susan and Ken to witness this document on April 15, 2020. We all signed it together in physically in electronic presence at 11:51 a.m. And so I've just given enough in that declaration to identify Ken and Susan's signature pages, because their signature pages would also note the date and time, let's say, of the witnessing. And so if they don't get back for another week or so, that's okay. They've all been identified. And if I'm alive now, if we're talking about an advance directive, and now I'm offering the advance directive to a physician, or no, let's go to the will, then we do need a separate declaration, I think, at that point, by whoever is presenting the will to the court. Oh, maybe not. Maybe the declaration ties up the loose ends. If the testator says that I say that I signed this in the electronic presence of Ken and Susan at 11:52 now on April 15, 2020, and they signed it and they witnessed, executed their signatures on their witness pages. Do we have enough? once those all get together.
So does, this is Lorianne. So does that presume that every signature of a witness will be electronic, that they're not going to be printing out the signature page and signing
No,
it
actually,
physically
Lorianne, I'm
and
assuming
then-
they're printing and signing, because I think to go electronic, we'd need to build more into this.
So how is the document that's signed by the witnesses going to be timestamped to match up with what the executor of the document is putting in that declaration?
I was just thinking that they'd fill it in by hand when they witness it.
Okay.
And this is Judge Donahue. Unfortunately, I've got to leave I have a 12 o'clock conference. It sounded like will this be the revised draft? Will that be addressed at next week's meeting?
Yep.
Okay, I'll try and make that then. Thank you very much for including me. I appreciate
You bet.
this.
No, thanks for your participation. Yeah,
Thank
let's
you,
go ahead
Judge
and-
Donahue.
I'm thinking, just trying to summarize where we are, and we've made good progress. This is kind of fun. In the preamble is we're going to rewrite the preamble the way Lorianne described it. And Lorianne, you decide if you want to include specific references to wills and powers of attorney, as John suggested, or whether you think the general is enough to incorporate everything that would fall into that. And then in sub 1, we're going to use language that aligns with the definition of electronic presence under the uniform e-wills. And then somehow in sub 2 or the next, we need to describe the process by which this happens. And that is the person signing in the electronic presence, the witnesses executing their witness statements at the same time, a declaration by the person who is signing the document that they have asked the people to do it in their electronic presence, and then a process by which these multiple documents get together, either complete copies of the same document or just the signature pages, as long as you have that declaration by the person signing. Does that summarize at least where we are at the end of today? Not that we're ready to vote to approve it, but to give Lorianne some direction for next draft for us to look at next week. Oh, with a specific exclusion for documents that require notarization. All right. Well, I think it'll be fun to see. And I think we've made some, I've made some improvements on this, and we'll see again if we love it when we get done with it. But I think these have been helpful suggestions for us to incorporate and look at in the next draft. All right, so everybody, we're just approaching noon. Thank you for your time today. We will be meeting again next Thursday, a week from today. Is that it? Same time?
Yeah, Elaine, it is. We're set for 10 a.m. on Thursday, the 23rd. Also, it's looking like, especially with e-wills, we're going to need an additional meeting. So I'll probably
so. Yep.
So I'll send out another scheduling link probably for 2 weeks in the future, if that makes sense.
So next week, same time, same places. Okay,
All right.
See you, everybody.
Thank you, everyone. And Lorianne, when you get the new draft, just send it to me and I'll get it out to the group. Thank you so much.
I'll do that. Thanks.
Thank you.